This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about subject matter jurisdiction, because a court cannot deal with a lawsuit if it doesn't have jurisdiction, something courts have been having difficulty with in this time of the year, and why the failure of a plaintiff to allege a short and plain statement of a claim is fatal to his suit. And even a pro se plaintiff must allege subject matter jurisdiction to be able to use the facilities of a court. In Jordan C. Kimball versus the State of California et al., the United States District Court for the Eastern District of California on May 27, 2025, resolved the dispute. Plaintiff Jordan C. Kimball, acting as his own lawyer, seeking leave to proceed in forma pauperis, IFP, pursuant to 28 U.S.C. section 1915, and for the reasons that followed, the court recommended that the plaintiff's IFP application be denied and that the complaint be dismissed without leave to amend. Plaintiff brought the action against Defendants, State of California, and the Sacramento District Attorney's Office. He stated the basis for jurisdiction is federal questions based on multiple federal statutes. Plaintiff alleged that from August 29, 2017 to January 15, 2025, he has been subjected to police brutality and obstruction of justice, including but not limited to suppression of evidence, wrongful denial of plaintiff's claims, intentional misconduct by law enforcement and prosecuting authorities. He sought $16 million in damages and also demands the initiation of criminal proceedings against the individuals for conspiracy, fraud, and attempted murder. One need not be absolutely destitute, the court noted, to obtain benefits of the informa pauperis statute. Nonetheless, a party seeking IFP status must allege poverty with some particularity, definiteness, and certainty. Plaintiff has made the required showing. The magistrate recommended that plaintiff's IFP application be denied, not because he's not poor, but because the action was facially frivolous and without merit, because it failed to state a claim and lacked subject matter jurisdiction, because it appears from the face of the claim that the action was frivolous. The court lacks subject matter jurisdiction, it concluded, over this action. Federal courts are courts of limited jurisdiction. Without jurisdiction, the district court cannot decide the merits of a case or order any relief and must dismiss the case. A federal court's jurisdiction may be established in one of two ways: actions arising under federal law, or those between citizens of different states in which the alleged damages exceed $75,000. The complaint failed to establish the court's subject matter jurisdiction. The complaint states no basis for federal court jurisdiction, and none is apparent. In light of the recommendation to dismiss plaintiff's federal claims, the court recommends declining to exercise supplemental jurisdiction over the remaining state law claim alleged under California Code of Civil Procedures Section 377.60 and 377.62 for wrongful death. A court may decline to exercise supplemental jurisdiction over state law claims if it has dismissed all claims over which it has original jurisdiction. Plaintiff's complaint also does not contain, as required by Federal Rule of Civil Procedure 8, a claim that provides subject matter jurisdiction because it does not give fair notice and state the elements of a claim plainly and succinctly. In considering whether leave to amend should be granted, the court found that the complaint is without merit because it failed to state a claim and lacked subject matter jurisdiction, and based upon the findings, it was recommended to the district judge that 1, plaintiff's motion to proceed in forma pauperis it be denied, 2, that plaintiff's complaint is to be dismissed without leave to amend, and 3, that the clerk of the court is directed to close the case. In my opinion, courts bend over backwards to help a pro se plaintiff to avail himself of the court's process, but their kindness is not without limit. The allegations were found by the magistrate to be frivolous, defeated the claim for failure to allege subject matter jurisdiction to the court because it was just not a cognizable allegation. This video was adapted from my blog, Salma on Insurance, which is available free to anyone who clicks on the URL salma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll gain access to the more than 5,050 blog postings. You can also subscribe to these videos on YouTube and rumble.com. They're free, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog and these videos so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please subscribe for a very small fee to my Substack publications. Thank you for your attention.